Hi, I'm Guy DiMartino. I am a Northwest Indiana estate planning and probate lawyer, and today I'd like to spend a few minutes and explain the different things that we can learn from Larry King's recent will contest that was filed in California. For those who don't remember Larry King, he was on CNN for million years interviewing people, and he interviewed some of the most famous folks in the world, and he was very famous. Larry was also known for having a number of wives. I think he was on his 7th wife when he passed away. So this is what happened. In 2019, Larry filed for divorce from his 7th wife because apparently she was sleeping with one of the Little League coaches or something along those lines. After he filed for divorce, a couple months later, he goes and he handwrites a will in which he writes wife number 7 out of the will and leaves everything to his kids equally. He gets sick in 2000. Just recently, Larry King dies, and now there is a contest over which will take, which will be probated. The will from 2019, which Larry handwrote, or the will from 2015, which left, I'm assuming, most things to wife number 7. So this brings up a whole bunch of issues for an estate planning and probate lawyer to tease apart for you. So the first question is a handwritten will valid? Can you have a handwritten will, also called a holographic will? Can't talk about the law in California, but I can tell you in the state of Indiana, a handwritten will is valid as long as it meets the criteria for a will. That the person had a sound mind, that the person was over 18 years old, that the person knew what they were doing, that the person put down what they wanted in writing, and if they want the will to be self-proved, to go into court, that you had the proper witnesses there, and then an affidavit or a statement from the witnesses that the person was over 18, the person knew what they were doing, the person was not coerced, there was no undue influence, and all the other statements that need to be in the will. If that stuff is there and it's a handwritten will, that will carry the day. So the dispute that wife number 7 is making regarding the handwritten will is that Larry might have lacked the testamentary capacity at that time because apparently he might have had a stroke or 2. Not quite sure, don't remember the facts. So that's going on. So she is actually challenging that the handwritten will should not take the day because Larry did not know what he was doing, did not have the capacity to make the will. It's the first thing. Second thing, apparently she is contesting the will, that the will is a violation of a number of postnuptial agreements that they had that would have been contracts that they entered into after their marriage, possibly regarding some disposition of property or things along those lines. Brings up the question, if Larry would have had his divorce lawyer write a new will at that point in time, would the will have been valid? Well, you know, possibly the lawyer would have probably did a mini mental status exam, discussed things with him, charted that he was in his right mind, knew what he was doing, and that will would probably take the day unless, of course, the postnuptial agreements will go ahead and rule the day. Brings up another issue. Well, Larry filed for divorce. Well, I don't know that filing for divorce is the same thing as going through a divorce, because many times people will file for divorce and actually reconcile and not go ahead and dismiss the divorce. You see, because once you're divorced, your spouse in the will, or now your ex-spouse, is written out of the will under the terms of the law. They are considered to have predeceased the person. So his 7th wife, if they were actually divorced, would have been considered predeceased, and she would not be able to take under the will. Also brings up the issue, well, even if Larry wrote her out of the will and it is a valid, it's valid, and a court says it's valid, a spouse can still go ahead and take under the will their spousal election. And that is typically, in most states, there's some type of form of that. Can't talk again about California law, and it usually allows the surviving spouse to go ahead and take and get a certain percentage of potentially real estate or personal property or both. But Larry was married 7 times. It brings up the question, did he have a prenuptial agreement with wife number 7? If he had a prenuptial agreement, many times part of the language of the prenuptial agreement is that the spouse can waive her right to elect to take under the will as the surviving spouse. So that could be in the prenuptial agreement. Now, this is going to go on probably for years. You're going to have attorneys on both sides. They're going to argue what is going on, but this could have been resolved quite simply if Larry would have been with his divorce lawyer and he would have done a new will or referred Larry to another lawyer to update his will at the time of his divorce. If you have any questions regarding a Northwest Indiana estate planning or probate matter, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.